I'm Ann Hodges. I'm on the board of Virginia Lera, and we're delighted to welcome three distinguished panelists today to talk to you about immigration law. Virginia Lera, as you all may know, focuses on employment, labor and employment issues in the workplace. And of course, immigration law these days is certainly pretty much essential for employers and employees in the workplace to have some at least basic knowledge of immigration law and immigration rights. Um, I'm not going to spend any time specifically introducing our three panelists because all of their bios are on our website and on their law firm websites. And I don't want to take away from any of their presentation time. Um, but they are all distinguished lawyers in immigration law. Our three panelists will start with Jesse Wright from Hyder Immigration Law, and then following that will be Brooke Hollmann, Hunton Andrews Kurth, and then Lakshmi Challa from the Challa Law Firm. I'll just say two things about them. Jesse and Lakshmi both graduated from the University of Richmond, where I taught for many years. So, a distinguished law school. And then Brooke from the University of Texas, also a distinguished law school. Just had to mention University of Richmond. And also, something that I think is really important is all three of them do pro bono work in the area of immigration law. And that's so essential these days. You know, if you've tried to hire a lawyer for anything, you know how expensive lawyers can be. And folks in the immigration process, most of them can't afford to hire lawyers. So it's really important that these folks contribute their time in offering pro bono services. Um, so what we'll do is we'll have the three panelists are each going to talk for about 10 to 12 minutes each, and then we'll have time for questions. And if you want to put questions in the chat, I'll be monitoring the chat and we'll ask those questions. But also when we get to the question and answer time, you can also just raise your hand or ask your question. So we're going to start with Jesse. Jesse's going to talk about employee rights. And also about some common misconceptions about current immigration enforcement. So I will turn it over to Jesse.
Thanks, Anne. Hi, all. Thank you for having me. This is a different platform than what I'm used to, so I'm excited to speak to some people who may not normally hear from immigration lawyers. Um, just a brief overview of what I do to give you context for what I'm going to talk about is I rep individuals in removal proceedings, so people who are the U.S. government is trying to deport. That varies, the demographic of who that is a lot more people these days than it was a year and a half ago. And I'll talk about what's changed. I'm invited to speak specifically about the rights of employees in immigration proceedings, but there's truly not many. And the few rights that are left are really not being respected these days. So instead, I'm going to kind of give everyone an overview of immigration law and what we're seeing happening now in immigration court and what you maybe can expect or anticipate would happen to non-citizen colleagues or employees and how you as employers or unions can step in and support those non-citizens. So the first misconception or important thing to know is whether or not someone is here legally is actually quite a nuanced inquiry. I often hear from people whose neighbors or employees or community members, their neighbor got arrested or detained and they're shocked because, that person had a job, they had a work permit, like they're legal. How can they be deported? You can have a valid active order of deportation and simultaneously a active valid work permit. Just because someone has like an ID with their picture on it that says USCIS, that doesn't technically mean that they're here legally or that they're protected. Another example of that is like student visas. I see a lot where people say, "Oh, but my friend, she entered with a visa. She's legit." If someone on a student visa stops attending their school during their semester or whatever they signed up for, that visa becomes invalid immediately. So that's a good example of how the documents someone have doesn't really determine whether or not they're protected from deportation. Next thing that's important to understand the whole environment of immigration is that immigration court, while it is a federal court, it's not an Article 3 court. It's governed by the executive branch, which means it's very subject to being influenced by the executive. It's run by the Department of Justice, which is within the grip of Donald Trump. So every administration, things in immigration change a lot for that reason. It's very tied less to statute and more to the whims of the executive. When someone is in immigration court, there's no counsel provided. It's pretty much nothing like traditional court that you've probably learned about or know about. We affectionately call it donkey court. The rules, there's not really federal rules of evidence that apply. It's all very vague. There's a lot of discretion given to the judges and a lot of imbalanced environment, especially right now with respondents' counsels and ICE attorneys. Obviously, ICE attorneys have quite a lot more say in immigration court these days. And like I said, no counsel provided, even if you're a child, even if I've represented many a toddler in immigration court. It's a wild thing, but not uncommon. Immigration court cases usually take a long time compared to if you're familiar with like a misdemeanor trespassing charge or something. Most of my clients that I represent in immigration court will be my client for at least 3 years. That's actually much faster than it used to be. Usually it was kind of a 7-year commitment. Because of the length of cases and how time-intensive cases are, there's really not a lot of pro bono options. And as Anne said, we do all offer pro bono, but I think it would be shocking to most people to realize how few options there are for pro bono in an environment where there is no counsel provided by the government. Just because the nature of immigration work is it's one case takes a lot of time and a lot of funding. So a lot of nonprofits direct more of their funding to general advocacy as opposed to direct representation. Usually, if you need direct representation pro bono, you're going to have to go through a private firm and be lucky enough to find someone who has the capacity to take that among their existing pro bono cases. Next misconception, and this is probably the biggest one that I'm sure my colleagues have explained a million times. There is no line to wait in for immigration benefits. This is a very common belief that people who came to the United States without the proper documents skipped the line or could have applied for something to come legally. The vast majority of people in the world who want to come to the United States do not qualify for anything. Vast majority of global citizens. And those who entered illegally without papers, the vast majority of them do not qualify for anything to allow them to stay in the United States. So when we're talking about immigrants and types of relief, it's truly a very small portion of the amount of people who are here. We don't have good framework to provide to regularize someone's immigration status. Next is there's a lot of political discussion on who's subject to enforcement right now. We know that Donald Trump and the Republican Party pushed for a long time to arrest immigrants with criminal history. That is by and large not what's happening. It's kind of just indiscriminate. While I would tell someone who had criminal history that they're more at risk than someone who didn't, even if you don't have criminal history, you are still at risk of being detained by ICE these days. Virtually everyone who's not a US citizen has a risk of being detained. Lawful permanent residents, green card holders, I would say have a significantly less risk than other types of immigrants or non-citizens, but they're not immune to enforcement. We're seeing the government, USCIS, reopen old cases and allege fraud. And maybe you have a green card holder who came to the United States 20 years ago, and they may open up that visa application and say, well, you lied about not having a wife. You did have a wife, and now we're going to strip away your existing status. We're seeing much more of that these days. And honestly, even people who have naturalized and become US citizens, we are seeing efforts to denaturalize some people. So pretty much if you weren't born here, you're at risk of some level of enforcement these days. Um, Immigration, this one's a hard one to explain. The biggest thing I don't think that most people, even in the legal world, understand about immigration is most of immigration law is not statutory. Most of our policy and day-to-day workings of immigration are executive orders or agency decisions. Because we don't have a lot of statutes, that's why things change so often. It's my personal belief that we don't have a lot of statutes because Congress usually doesn't want to touch immigration. Most elected representatives don't know enough about immigration to want to put their name on a bill about it. Most of the statutes that we've had passed in the last 10 years have been pretty negative for immigration. You may have all heard of the Lake and Riley Act. I think this was the last big one that passed last year that really ramped up enforcement. But other than that, it's pretty much all executive orders, agency decisions, regulations, and they change a lot. And also because of that, when times change, like there are things that maybe were in the zeitgeist of 30 years ago, but times and the demographic of immigrants change and the cultural attitude towards immigration changes, but the laws on the books don't. And so how our country has historically dealt with that is we just stop enforcing things instead of repealing them. So what we're experiencing now with Trump is a lot of what Trump's administration is doing is perfectly legal because he's using these laws on the books that no one bothered to repeal. That's for an example on that is the alien registry. I'm not sure how much this has made it into mainstream non-immigration law news, but this administration has restarted the alien registry program and is enforcing a law that if you are here undocumented in any capacity, you are legally required to register in an alien registry. It's terrifying, but it's legal. There's a statute to it. And no president has really touched that for years because it's kind of draconian, but it's there and they're using it. And kind of on the same token of that, it's important to know that the patterns of enforcement that we're seeing in this administration change very rapidly. So I will tell you what's happening today, and that may not be valid 2 weeks from now. I will go over like kind of the different changes that we've seen since January 2025, and you may be shocked at how many things have changed. There's been different trends. For example, there was a huge wave of Department of State terminating student visas just because. That went on for a couple months and then they stopped. There were a move to reopen old court cases, so old deportation proceedings that had been paused under Obama, under Biden, and even way before Obama. For about 6 months, ICE was filing those. It was completely unclear which cases they were targeting and why they chose some and not others, and then they just stopped. Same with the courthouse arrests. I'm sure you all have heard of ICE being present at courthouses and kind of trapping immigrants, so to say, of dismissing their case inside the courtroom and then having them come outside the court and be arrested and processed under something called expedited removal that removes your ability to apply for things like asylum. That was happening for about 4 months, and now here in the Virginia courts in Northern Virginia, I haven't seen an ICE officer since maybe October. And just because there's not really any official announcement or anything, you just have to have your ear to the ground and see what's happening. And that's the best way to advise clients these days. Truly, the biggest tactical weapon this administration is using against immigrants is the element of surprise. It's all pretty unprecedented, even if it's legal. And there's not really providing any insight onto why they are using certain enforcement tactics, why they're doing it for a certain amount of times and switching. So before I get into what all of this means for employers and how you may use this information to assist your employees or colleagues, are there questions about what I've said so far? Is everyone clear on that? The MO that immigration law bad right now, this thing. All right. If not, Now I'll pivot to talking about what we can do as employers and unions and community members. So from what I've said, this might mean that you may have long-term employees or colleagues that have never had any issues, worked for your company 20, 30 years, and then all of a sudden they can disappear or lose work authorization. Uh, Very common situation that I've had many consults about. Additionally, you may have employees or colleagues who stop showing up to their job out of fear. I've dealt with a lot of that a couple months ago when there was a wave of fear in the Richmond area about ICE being present. We had a lot of clients who didn't take their children to school, didn't go to work themselves. So that's something to be aware of. If you have a non-citizen colleague that is not showing up, you may want to check in about that. And then also we have a lot more people than usual non-citizens than usual, who are choosing to voluntarily return to their country. That may be a way that affects your company and, I mean, generally affects the labor market. So what can you do when these things happen? Employers, it can help out in kind of a non-traditional capacity in these situations. Usually everyone's gut reaction is to ask, like, can I sponsor them? Can I petition for them to get them out of ICE detention? And 99.999% of the time, the answer is no. Employment-based petitions are very narrow. A very small set of circumstances would allow someone to petition for an employee. I'm sure my colleagues will talk more about that in this call. Truly, what I think the best way to assist your non-citizen colleagues and employees it's cash. It's just money, help pay for lawyers. There's higher filing fees. One of the things that was passed in the One Big Beautiful Bill was immigration filing fees have increased exponentially. Things that were once $200 are now $5,000. And usually these fees are due pretty quickly. For example, if you have a appeal in immigration court, which is common because the vast majority of cases in immigration court are being denied. My clients have 30 days to file an appeal from the date of the judge's order. That fee used to be $140, and now it's $55. It's a lot of money for most people to come up with within a 30-day window. I've had employers cover that fee for some of my clients. Then also, like, work permit renewal fees have gone up a lot. That may be a way that you all can help us by either funding it now. The legality of whether an employer is allowed to, put that in someone's paycheck, the amount for that I can't speak to. I will leave that for the labor law experts. But even if it's something that your company doesn't want to take on directly, like if you don't want to be the one paying for it, you can organize fundraisers or things like that to help people. My parting words for you all is, again, the element of surprise is the tactical weapon used the most. An enforcement tactic used 1 month's going to change the next. It's truly more worthwhile for employers to have plans in place for how to react instead of how to prevent. Question I get a lot is, how do I stop ICE from arresting my employee? We can talk about warrants and whatnot, but at the end of the day, if ICE wants to arrest your employee, they're going to do it. So better to have a plan in place, how you can support your colleagues after arrest, than how to prevent it. That is all I have for you. I don't know if we want to open up for questions now or after all three of us, but Anne, I think you're muted.
Yeah, I think we'll move on to Brooke, and then Lakshmi, and then open it for questions at the end.
Perfect. Hi, everyone. My name is Brooke Hollmann. I am here to talk about ICE in the workplace. And it's interesting to have a panel with people with all sorts of different experience and clients as well, because when I talk about clients, I'm coming from a place of the client being the employer, right? So a lot what I do is I work with large clients, small clients, those being employers in a various different types of industry types, companies that, from all sectors. So when we're talking about that in terms of ICE in the workplace, this can happen in all sorts of different industries, work type, locations. But hopefully what I'll say is a little bit broader so you can apply it, especially if you are an employer. If you have work in a company as kind of a HR or maybe in the legal side or just more on the operations, you have a better insight of what can happen and give you some information on empowering you to know what you can and cannot do. Okay. So as we are all aware, we've seen in the news that worksite enforcement has increased under the current administration in various contexts. And I'll talk a little bit about what kind of contexts those are. But with that in mind, some important topics or important things to remember is, or to know, is to be able to understand the various types of ICE activity, the common documents and significance of those documents. So this will be able to dictate what ICE agents can and can't do, where they can and can't go, theoretically. Designing a plan of action. I know, a lot of times, especially in this environment, we have to be reactionary, but I do think there are some things that you can do to be proactive, mostly in terms of knowledge. I like to say that there's power in knowledge and there's power in preparation. And that's the best position that you can be, especially in an environment that you can't control. At the end of the day, you can have the most knowledge and be as prepared, but you can't control anything. But if you have those two aspects, you are in a better position than if you don't. And then lastly, I can talk about some real world examples that I've seen, especially in the I-9 context, for when ICE agents come to the workplace asking for those documents, and give you some insider tips of what to expect. So starting off, the three types of ICE activity in the workplace that we are seeing recently are in those I-9 audits. So that's when the ICE agents are coming with a notice of inspection. They're asking for your I-9 documents so that they can confirm that everything is up to par and that you don't have any sort of violations in your record keeping. Administrative arrests. So this is where ICE agents are looking for specific individuals. And then lastly, work site raids, where they're looking or targeting groups of people, which does tend to come up in the news quite frequently. But these other types of activities are happening. They're not as nationally, posted. But if you are an employer, you should be aware of these other two. First, talking about ICE documents. Why is this important? Like I said before, the specific type of document that is presented when ICE is at the work site dictates what ICE can and can't do, where they can and cannot go. So it's really important to understand that, so that, if someone comes into your office, you already have that knowledge of at least understanding that there are certain things that they can and cannot do. As a reminder, ICE agents are allowed to enter public areas without consent. So when I say public areas, I'm talking about lobbies, receptions, parking lots. They are authorized to do that, but without consent, that's just the where we are. However, access to private areas do require judicial warrant or employer consent to gain access. So even if, simple knowledge of knowing that you need to be seeing some sort of warrant, and we'll talk about the different ones, or that an ICE agent needs consent to be able to go into a private area, is important, because what happens is a lot of time ICE agent shows up, no one knows what to do, everyone's very stressed out. Maybe the ICE agent says, oh, can I go to wherever part of the manufacturing plant? Can I go to everywhere? If you don't say no, and if you give that consent, then you're already putting your employees and your company at risk. So even having that basic knowledge is important. If we're talking about specific warrants, the three main ones that I would focus on are the judicial warrant. So that is a document signed by a judge. So if you're already trying to figure out what type of document you're looking at, look to see if it's signed by a judge. That will be your indicator that it is a judicial warrant and that you as an employer must comply with it. This does allow an agent to go into private areas, but you need to make sure that you read that warrant very closely, because it is going to list exactly where the agent can go and the scope of the search. So, make sure that, again, that it's signed by a judge, because sometimes agents can be a little bit tricky, and they say, oh, here's a warrant. You need to be thinking in your head, what type? Because the second type of warrant that I want to mention is the administrative warrant. So this is not signed by a judge. And this is when the agent is looking for an individual person. Importantly, it does not authorize entry into private areas. So you need your permission or consent to enter those. So if an officer says, I have a warrant, you're looking to see whether it's signed or unsigned. Signed, it means judicial warrant, you must comply. They can go where it's listed in the warrant. Administrative warrant, not signed, you do not have to authorize them into a private area. But if you give them consent, they can go there. So keeping that in mind. And then lastly, the notice of inspection. This is more of a document that triggers production of I-9s a lot of the time we see. Again, if we're talking about where an agent can or cannot go, they are limited to that public area and they can't enter the area without consent. Okay, so let's say an agent walks in. What now? This is where your plan of action comes into play. We know that the current administration is thriving on surprise and chaos. But if you have a plan of action in place, if you've worked with your company, what we do is we recommend that our clients, the companies, have a plan of action, step-by-step guide for your front of house, whether that's a secretary, whether that's some sort of individual who monitors the lobby. It will be a surprise if an ICE agent shows up, but that's where the surprises should end, because that person has a go-to guide of what they need to do. And sometimes it can be basic things like saying in that document, okay, step 1, ask the agents to wait in the reception area and contact the manager or the supervisor, right? Again, when we're thinking about consent, we don't want the officer to ask to go somewhere and the front of house person not really understand the consequences and say, oh, come on up. Let's go try to find the supervisor. We're not doing that. We're asking them to wait in the lobby while we figure out the next steps. Again, confining their presence to the lobby, gathering information about the officers. This includes writing down their names, their badge numbers, their contact information, because this is likely not the only time that you're going to see them. There might be some follow-up. And then inspecting the document to determine what type of request it is. Maybe at this point you put in your contact person, whether that's the manager or the supervisor, maybe that's your legal team. Hopefully, if you have sponsored employees, you are working with outside or inside immigration counsel who can guide you through what the request is. So if the front person doesn't have that knowledge to be able to identify what type of warrant it is, be able to read that, make sure that they have the contact information of someone who does, so that still while they're confined to that public area, you can have someone who's trying to figure out the bounds of their activity. Talking a little bit about my personal experience and our firm's experience with I-9 notice of inspections, we are seeing a big uptick of this lately. And so it's really important that one, you have a plan in place, and also that you have outside counsel or inside counsel that is able to help with this I-9 inspection process. So again, this is if an ICE agent comes to your office, they hand you a notice of inspection asking for I-9s. It is going to be quite a lengthy process because you're going to have to work and get all those records to be able to pass along to the agents. You're not going to do it in the same day. You shouldn't do it in the same day because you need counsel to be able to help you make sure that you have everything and are able to comply with the request. Just some broad guidance on this. Each case and each experience is going to be different. Each agent is different. It is very interesting working with different ICE agents who have different personalities and different ways of them actually processing their cases. I'll talk a little bit about the various ones I've seen, but a basic point, but it is incredibly important, is to stay organized. If you have an attorney who is able to assist with this, I recommend that they be the intermediary between you and the ICE agent. They send a G28 immediately and indicate that they'll be the person handling the requests moving forward, just to be a buffer and to be able to talk with the agent on your behalf. And it's much more cleaner than you trying to, as an employer, trying to communicate with them. Like I mentioned, each request is going to look differently. Sometimes the agent will ask for the I-9s for the entire location. Some will ask for just certain I-9s. And so it really is going to be based off of the agent and what they're looking for. And like I mentioned before, they're going to run their inspection differently based off of the individual. Typically, you have 3 days to produce all the I-9s, but I've also worked with agents who are a little bit more understanding. Say you have 100 people who work for you and they've requested 100 of the I-9s. If you ask nicely, there is a little area of flexibility. And I have worked with ICE agents who have said, we understand, we'll grant you a 2-week period. I've also worked with ICE agents who stick to that 3-day rule. So it all just depends on the agent and your communication through the attorney with them. After that, the officer, after you hand over the I-9s, I do recommend that there's going to be one part of the process where you're actually giving over the I-9s, and the officers will say, oh, I can come back and I can collect them on Tuesday. And my recommendation is to say, oh, well, thank you for that offer. But, we'll have a member of our team drop those off to you. People and employees get very uncomfortable, understandably, with ICE in the workplace. So we try to reduce that as much as possible. So after they review the I-9s, they go through their processes, they identify maybe some technical or procedural failures. There is a possibility, and this has happened, where they issue you a notice of suspect documents. What that is when they were doing their system checks, they noticed some sort of fraudulent document. So maybe an employment used a social security card number for an individual who no longer is living. And they did their security checks, and in their database that popped up. And they could in that notice of suspect document say, we identified male John. It looks like his social security number is not accurate. We'd like to talk to John. It could be some sort of mistake. We don't want John to have this mistake, this issue following him. So it might be good just to sit down with him to see what this issue is. And what I would say is that you're not responsible for facilitating this. It's important to remember, you can tell the officer very nicely, I can inquire about getting you a new document, but we don't feel comfortable facilitating this meetup. I'll stop there. If anyone has any questions at the end, please let us know. Passing on.
I do have one question that was in the chat that I'm going to ask because I think it applies to both you and Jesse, and then we'll move on to Lakshmi. The question is, what are the limits of thwarting ICE presence or enforcement in a courtroom or court offices not open to the public except by specific permission?
Jesse, that would probably, I'm not in a courtroom, so.
Could you repeat the first part of the question?
What are the limits of thwarting ICE presence or enforcement in a courtroom or court offices not open to the public except by specific permission?
I think I need clarification to answer it. Are we talking about, is ICE allowed in a courtroom, like a public courtroom, or like judicial chambers?
It sounds like that ones that are not open to the public, do they have to let ICE in? And it was Chuck Miller that asked this. So Chuck, if you have something to add in to make it clear.
Want to give me some more context, Chuck, that would help me out.
Well,
Well, if not, I'll just say generally,
okay.
I- most public buildings, you don't need a warrant to enter, and most courthouses are open to the public. Um, if it comes down to like getting into like judicial chambers or something, I would think the judge would need to give permission into the chambers. Then there's also the complicated part of that question is whether we're talking about federal government entering, like federal agents entering a federal government property. That I think is kind of murky, and I don't know how to answer that. So
Yeah, he did in the chat say private offices in the courtroom. So I'm
okay.
assuming you would say
I would say, yeah, they
they
would
need
need
to have
permission
permission.
in a private, something that's not open to the public. Whether or not that's a federal private office, that I think I'm not very clear on since ICE agents are federal agents. And if they're on federal property, what permission do they need? That I don't really know.
Yeah, they might well have access to
Yes.
that as federal agents. Thank you both. And over to Lakshmi.
Let me share my screen.
I need you to turn your camera on so that I
Yep.
can spotlight you also, please.
There we are. So my name is Lakshmi Chawla, and I've been practicing business immigration for over 30 years. Yesterday, Chief Justice Roberts had a response. He looked at the Solicitor General and said, "It's a new world. It's the same Constitution." That's the sentence of the day. That should be the sentence of the year. And frankly, it's going to be the theme of everything I'm talking to you about today. But here's the thing. It's not just immigration lawyers that need to understand all these immigration issues, but as counsel to employers who have people on their teams whose lives and careers are being decided by these policy changes, they're being impacted in real time. We are currently living through the most aggressive dismantling of business immigration infrastructure in modern history. And most of your clients don't even know how much of it directly affects them. H-1B fees that are structured identical to import tariffs. A consent optional racial profiling doctrine is now being nicknamed after a sitting Supreme Court justice. Warrantless home arrest, pre-admission ports of entry policies where your Fourth Amendment rights are, let's say, negotiable. Social media vetting that requires foreign employees to make their entire on lives public to the consular officer. An expedited removal system at airports where one customs and border protection officer, no judge, no lawyer, no appeal, decides whether your client's best engineer goes home or gets on a plane. The Constitution has not changed. What has changed is the velocity and creativity in which this executive branch is testing its limits. The good news, and yes, there is good news, that the courts are pushing back across the board, the Ninth Circuit to the Supreme Court itself. Judges are reminding this administration that it's the same Constitution. APA challenges are landing, injunctions are holding, and anyone who lived through Trump 101 will tell you the legal system did its job then, and it will do it now. But until then, employers need a strategy, not just a visa application for their employees. They need to be thinking about immigration the way they think about any enterprise risk, proactively, comprehensively, and with the explicit understanding that the gap between what the law says and what the officers are doing has never been wider. So let's talk about what's actually happening. And I will try to go through, because we've got to stop at 2, right, Professor Hodges? So
Yes,
I'm going to blow through this, but I will make sure my PowerPoint is available in case anyone needs it. So what exactly is going on? So recently this year, the president, through executive order, instituted a $100,000 supplemental fee for any new H-1B visas. H-1B is the largest used visa for work authorization in the United States. And because through executive order, you can't really change. Remember, we're dealing with administrative law. So only the USCIS through notice and comment can make changes. He attached that to entry into the United States so that it became effectively an import tariff. Then there is what most people don't realize, if you are from China or India, the backlog for getting permanent residence in the United States is 10 to 13 years. And, you know, on the same hand, there's so many structural challenges that are facing employers. So this $100,000 fee, they signed the executive order in September on a Friday or early Saturday morning. I was in bed and all of a sudden the phone started blowing up because there were people all over the world thinking they had to race back before its effective date. That problem was, even made worse because you can't get back in 24 hours when it was supposed to be effective. And while we were trying to wrestle with all of this, there was I think a tweet by the White House administration that said it doesn't apply to those people who are already on an H-1B visa or have an H-1B classification. That was great. So in the interim, everyone started filing applications. October 23rd of 2025, they issued a clarification, and which in some instances was contradictory to all their comments they made before. So we've got several H-1B petitions that are just being held in abeyance because we have argued that because these petitions were filed between the date of the executive order, but before the clarification, that all the other messaging, whether it was through USCIS own policy, whether it was through the Department of State, was contradictory to what they finally outlined. So it was utter chaos. The H-1B lottery, there are only 85,000 H-1Bs that are allotted per year. 20,000 goes to master's degree holders. This year, they decided to restructure the system based on how much you're paying the employee. So for all of you for most of you don't know, the H-1B program has two elements. It's the Department of Labor that is trying to ensure and protect U.S. workers, and then there's the USCIS. So the wage that you pay an H-1B employee is dictated by the Department of Labor online wage levels. There are 4 levels. So the higher level you pay your employee, the more chances they have for selection. And there is no exemption for nonprofits and other organizations. The area that I would see that would be most impacted is, I don't know if many of you people know this, but 23% of all licensed physicians in the United States are foreign trained. Of that 23%, I think it's 64% are serving in medically underserved areas, and 46% are serving in rural areas. They're not going to be paid a lot. So to make this even worse, they serve nearly 21 million Americans that live in that area. And because they didn't make a distinction between, how they would structure this, or it becomes very challenging for those areas to recruit new doctors. Expanded enforcement and compliance. I think Brooke went through this previously, so I can skip over this. Processing delays is unprecedented. So, but if you pay the USCIS $2,805, and I think the fees just went up recently to even higher, that they will process your petition in 15 days. Now, when this started out, it was, I think it was 1,200 and something when premium processing first started. And you could call and talk to the adjudicator. And at $2,805, I should get his cell phone number. But you don't. And you can't even reach them through email, or the only thing you're getting as a result of this is faster processing time, because the backlogs are ridiculous. And in the same time, while they're experiencing ridiculous backlogs, there used to be certain protections in place to allow people who are already in a certain work authorized status to have the ability to continue to work on that status while their extension is pending. So if they do the I-9 process, they'd show their receipt notice and proof that it's been filed prior to the expiration, and they could continue working for 240 days. So in October of this year, they eradicated that for a number of different categories that are based with not really the H-1B or any non-immigrant category, but through an employment authorization document. Those work authorizations now are taking 1 year. So those people who relied on that for work, and the employers who relied on those employees, have to terminate them for a 1 year period of time, because there's no way to expedite it. And the backlogs are just too long. The green card backlogs. So there are a certain number of allocations for permanent residents in the United States, and then it's broken down per country. So clearly, the country that has more individuals coming to the United States for permanent residents are going to experience a backlog. That happens to be India and China. So for the average, MIT grad engineer who's working for, ABC Inc., who happens to be either an Indian or Chinese national, has to wait 10 to 12 years to get a permanent resident status. So what happens is if their employer doesn't apply by the time their children are 10 years old, the child will age out, which means they don't get to benefit from this plan, even though they've lived here pretty much all their life. And they have to go through that process all over again. So we've worked with a number of people who have to send their children to Canada, for example, because their children are not able to reside in the United States. And then the children, return back either on a student visa or on another work authorized status, and the cycle starts all over again. The US lockbox and failures has been one of the most frustrating issues I have dealt with. And I don't know whether it's lack of training or there's not enough people. They used to use a lot of independent contractors for that, and I think they reduced that some time back, and that may be the reason. But I'm not talking about simple deficiencies. I am talking about when you file with the USCIS at its lockbox, you have to include all the filing fees, and they're pretty extensive. And so we filed 2 petitions at the same time for the same employer for 2 separate individuals. These are world-renowned chefs. What they did at the lockbox is they mixed up the fees so that one individual got 2 receipt notices, and they returned the other person's petition back. You think that would be an easy remedy to fix? I could call them, and the fact of the matter is, every petition you file, you only get 1 receipt notice. So the fact that I got 2 for one person means 2 sets of checks. Over $3,000 were cashed for one individual, over $6,000 for one petition. And we've been trying to work to get this rectified. We have seen instances where they're even mixing up, evidence for one and putting it in with the other. But that is just an additional frustration that we're having to deal with. Now, these are the key immigration pathways that most people undertake. Like I said, H-1B is probably the most widely used. We do a lot of multinational managers. That's if there's a multinational, if the company has a subsidiary parent or affiliate overseas, they can transfer employees between the two. So as you can see, it's almost an ABC list of options available. And then there are various pathways for permanent residence in the United States. But what is happening and what is available, what is needed in the market, and these new policies make absolutely no sense. There is wide documented evidence from very nonpartisan groups that will tell you that there is a tremendous gap between the skills in certain areas. And I'm not talking about even highly skilled. I'm talking about, because of what Jessica talked about in terms of enforcement, you're seeing the impact in agriculture. You're seeing the impact in construction. You're seeing clearly the impact, the largest number of graduates with AI capacity, with degrees in artificial intelligence and cybersecurity, a vast majority of them foreign nationals. So it's going to impact us in all industries. And we have to remember that these employees are not just obtaining salaries, they're also consumers, right? So with the crackdown on foreign students, what that has done is that has decreased international admissions to the United States. International admissions is what has been subsidizing our tuition rates. And in fact, I'm trying to think, I think it was either Purdue or University of Illinois Champaign was the first university to actually get an insurance policy in case foreign admissions went down. But it does get better. There are, and I told all my clients this, I said, just wait. We have to wait until these cases get to court. And once we saw that in Trump 101, that, he started, the challenges, all the things that they were doing to nip away on the various non-immigrant classifications. And their target was the H-1Bs, mainly because that's the largest or the most used for foreign nationals. And we found that, time after time, the court struck down the policies from the Trump 101 administration. What I did in my practice is I went back to the congressional records, because and a federal agency cannot institute any policy that is in direct contradiction to congressional intent. So I would go back to congressional intent and pull that up and submit that with the filings. Like I said, I've been practicing for 30 years. When I started, my petitions were about this big. And now I think there's a little forest that gets deteriorated every time I file an immigration petition. The social media vetting, they had started that in September. As a result, visa wait periods have just backlogged ridiculously. There were people already with an appointment and they were supposed to return to the United States, but their visa had expired. They had expected, because they had the appointment, to get a new visa stamped, but the next appointment was like 3 or 4 months away. So this social media, they whether it's at CBP or the consular office, more importantly CBP, they have a way of backing up your phone or trying to extract things even that you deleted. So I'm at a point where I'm telling people, if you're traveling, grab a phone that you can pay as you go, that you don't use on a day-to-day basis, which is ridiculous. But that is where we are heading right now. Now, before you're admitted to the United States, so this is how it works because because I live in this world, I forget that most people don't understand the process. For some petitions, you have to file with the USCIS. It gets approved. Then if the person is overseas, they need to go to the U.S. consulate under the Department of State to actually obtain a visa to enter the United States. A visa is not an immigration status document, it's an entry document. After they get their visa, they travel over to the US, so they get inspected by Customs and Border Enforcement. Before you're admitted to the United States, you don't have any constitutional protections. So they get to do a lot more at the ports of entry than they could otherwise. And we had someone just the other day who'd been coming in and out as a visitor. His wife is a US citizen. They had looked at his phone records, they backed it up. They could not find any substantial evidence that he was doing anything really to that would violate the terms and conditions of his stay. But they told them that, you know, I'm looking at you and you just don't seem like you're telling me the truth. So they're at that point, they're supposed to allow him to voluntarily withdraw his request for admissions. Instead, they put him in expedited removal proceedings, and he can't come in for 5 years. And told his wife just to file an immigrant petition, didn't even explain to them what the ramifications are. And so we are going to be fighting that. And when they allowed for CBP to check, you know, your personal records and check your phone, really it was for, is this person part of a like child pornography ring? Is he doing, not for, is he going to be working in the United States? And do we really have, do we need to look at what he's been saying on Facebook or Instagram? But that is exactly what they're doing. And I wanted to say that before I leave you today, just one more voice in all of this. Not a court, not a policy brief. James Wilson of Pennsylvania, an immigrant from Scotland, one of only 6 men to sign both the Constitution and the Declaration of Independence. He was one of the 6 original Supreme Court justices appointed by George Washington. He stood up at the Constitutional Convention in 1787 and he said it plainly. He wasn't speaking theoretically. He was just speaking about himself. He said, I have a fear of being incapacitated. Those were his own words. From holding a place under the very Constitution, which he had shared in the trust of making. He was also speaking about Robert Morris, who came from England, about Thomas Fitzsimmons, who came from Ireland. He said he had personally experienced the degrading discrimination that was being proposed and the mortification of it. And from that mortification, he drew a constitutional principle that it was wrong to deprive the government of the talents, virtue, and abilities of such foreigners as might choose to remove themselves to this country. And the founders did not intend for these protections for some abstract future America. They wrote them because the people in the very room that were standing before them needed them. 239 years have passed between that room in Philadelphia and yesterday's courtroom. And yet a Chief Justice of the United States looked at a Solicitor General who was asking him to read that very same document differently and said, it's a new world, it's the same Constitution. Wilson wrote it or took part in writing it. Roberts is protecting it. The question for your clients and for this profession is whether we do the same. I thank you and I look forward to your questions.
All right. Thank you, Lakshmi and Brooke and Jesse. We are definitely out of time, so if folks need to leave, they certainly can, but happy to take any questions from the audience. Either you can type them in the chat or just raise your hand or speak up. Be delighted. I know they'd be delighted to answer your questions.
Hi, this is Michelle.
Michelle.
Oh, sorry.
Yeah, go
Someone
ahead.
someone brought up the 3-day rule previously, and I wonder if you could talk a little bit more about that, please.
Sure, that was me. That was in the I-9 context. So usually what happens if you're issued a notice of inspection, that's the document that the officer or the agent brings to your office. They'll actually explain exactly what they need from the I-9s, whether that's all the supporting documents that you collected as an employer, whether that's just the I-9, form that you filled out. The I-9 inspection notice will be clear on what you need. And usually it's 3 days for you to produce those documents. But like I said, sometimes the officer will give you a little bit more time, especially if it is a pretty robust request.
Okay, thank you.
Mhm.
Other questions? Anybody else? Not seeing anything else in the chat. All right. Well, since we're out of time, I just want to thank our panelists for speaking. It's obviously very educational. Um, and somebody in the chat just said very informative. Several people are commenting positively in the chat. It was really, thank you all so much. We all need to learn more about this. And I think, as you all said, it's changing all the time. And so it's great to have you to keep us up on what we need to know.
Thank you for having us.
Yes, thank you.
Thanks.
Have a good rest of your day.
Bye.
And for those, we will have a recording posted on the Virginia Lera website for members of Virginia Lera. So if you're not a member, or if you know someone who's not a member and wants to see this great presentation, have them join the organization.